Bismillahirrahmanirrahim. Before I answer that question, I just want to say, it's this extreme pleasure as a UK practicing lawyer coming here and meeting with the members of the profession here, and especially encouraged by the judiciary, especially last night and this morning we met His Honourable Justice Jawad Hassan Sir for inspiring as in giving us the confidence that the judiciary has given us the blessings for such an event. The pre-action protocols that are sort of designed they have one thing in common, and that is to try and make the parties settle their disputes before engaging in huge, expensive trials. The objective is be honest, give disclosure, have an understanding, and before you embark upon expensive litigation, you need to follow the pre-action protocol procedures. If I issue a claim in court without following the pre-action protocol procedure, the first thing the judge would criticize me, and he would say, or she would say, that why haven't you followed the pre-action protocol procedure? And the pre-action protocol procedure is designed to make sure that we do whatever we can to try and settle matters before the parties become entrenched in their positions. Now, ADR is an essential part of the civil procedure rules. Lord Dyson, who was the master of the rolls at the time, said that consensual settlement is part of our civic society, and also said that it's in the public interest to make sure that people who get access to justice must be in a position to be able to seek that justice, whether it's in the form of a court, a resolution, or ADR. And also, I have to say, it's our Islamic duty to ensure that justice is given. The verse of the Quran, Ya ayyuhalladhina amanu, kunu qawwamina bil qist. O you who believe, try to seek justice firmly. And I think the whole purpose is to seek fairness, openness, and to make sure that within the system, we are given the opportunity of considering ADR. Without going into too much detail, but if you don't consider ADR within the CPR rules, in Pakistan, I've been talking to judges and I've been talking to lawyers here, the whole concept of adverse costs is an alien concept. It's there, but it's not practiced as much. And I understand that different provinces have different rules. But in the UK, yes, the loser pays the winner's costs. But if any of the parties do not subscribe to the rules, the danger is there's going to be an adverse cost order against you for not following those principles, for not following those protocols, and for turning a blind eye to the procedures that have been put in place. So within the proceedings, the judges try to ensure, and this is coming from the judges themselves, so it's enshrined within the CBR rules, but because the judges are behind it, the lawyers are forced to think in that way, and we as practitioners over there have to think in the same way, because if we don't, we know that the cost consequences are going to be great. The whole concept of ADR, even in the middle of the trial, we're about to, the pleadings amended, we have what they call directions questionnaires, which we have to file to the courts. And within that directions questionnaire, there is a question, have the parties considered ADR? And if I simply tick the box, no, the judge and the court will want to know why. And even more so, if the parties say yes, that the courts encourage a stay in the proceedings. Proceedings are stayed. Depending upon the case, the proceedings are stayed for 4 weeks, 2 months. I'm involved in a case in the moment where a Chinese company is dealing with matters with a UK company, but the proceedings have been stayed because they are actively trying to find ADR. One of our problems in ADR or within the court system is taking the witness statement from a Chinese person in Shanghai. It's very difficult. So rather than spend the energy trying to understand his case, the objective was to see if we could get somebody together who can actually resolve the issues and narrow the issues down in order to resolve the issue, and time and money. Alhamdulillah, I have to say that ADR in that case has worked. And I think that our mindset is that if we don't consider ADR, that we cannot, we will be questioned by the courts, we will be questioned by the judiciary as to why you haven't considered that. And of course, if it fails, it's not compulsory, but there is a legal requirement that you have to consider it. You can't just ignore it. And I think this is the thing in Pakistan, where a lot of work has to be done. But honestly, it's very encouraging to hear that there are practitioners who want to see that arbitration and ADR forms part of the mindset. And for the young lawyers, it gives inspiration that, things are going to be changing to be in a positive way.